Good morning to my respectful lecturer, dear panelists, and my dear classmates. I'm Yasajan Mohanir. Today I'm going to present my legal research project in the topic of the effectiveness intoxications as a defense in the rape cases and an exploration justice for the rape victims. This presentation will be covered to the subtopic introductions, problem statement, objective and research methodologies, literature reviews, finding analysis, recommendations, and also the conclusions. Let's move to the first topic. Okay, first is introductions. Before I'm going to explain the introductions of my topic, I would like to explain briefly what is the intoxications and also the rape definitions under the Penal Code of Malaysia. First is intoxications. Intoxications is mostly covering under sections 80 sub 85 of the Penal Code. It is explained that insociation is not considered as a defense in any criminal cases in our Malaysians unless when the case was fall under clause 2 of sections 85 of the penal code, which is that when the person was intoxicated but innocent during the act was what they are admitted, then in these cases the accused was be acquitted from the charge. Second is the sections the 375 of the penal code, which is explained about the rape. Rape is the man was committed in a rape against a woman, which is has a sexual intercourse with a woman without a consent, against a will or with the consent of the woman when they put the fear of death. In these cases, when a man was admitted to the act of the rape who fulfill this kind of the elements, the man was be charged under section 375 of the penal code. First, let's we move to the point of my introductions. First is the concept of investigations as a defense in the rape cases has been a critical topic to debate to identify the clear clarity of the criminal justice to use the defense in the criminal cases. In this point, it was explained that the concept of insubordination as a defense in the criminal cases or in the rape cases has been a critical topic to debate to identify the clear clarity whether the institutions can be established as a defense in any criminal cases or not. When the institutions are established in the criminal cases, what kind of the negative impact that will be faces by the country when a country criminal justice system use the institutions as the defense in the rape cases or any other criminal cases. Second is the main purpose of this research is to identifying the position of institutions in the defense in the rape cases to leading need to further research and exploitation justice for the rape victims. If institutions used as a defense of the criminal cases in the rape cases, what kind of the research we did, what kind of the we need to consider is first things consider is first things what kind of the justice they can be get by the victims when they accept the insurrection as a defense in the rape cases. Thus the rape victims cannot get the fair enough justice from the judge of the court because then when the intoxications used accept as a defense in the rape cases, the accused was acquitted from the charge of the rape. Then what is the justice for the rape victims can be get? So that is the main loopholes when you use investigations as a defense in the rape cases. Second is the prevalence and the legal acceptance of the investigations as the defense in the rape cases have a significant implications of the legal system, including the perceptions of the rape victims and the administrations of the justice. In this case, when a legal, as I have explained above earlier, when a country of the criminal justice of a country accept is cases as a defense in the criminal cases, it can be impact this it can be it can be give the negative impact towards the legal system, including the perceptions of the rape victims. When the investigations as used as a defense to accuse the charge, to accuse the accused from the charge, then this society, the community is is be the communities of the country of the community of the country, they be blaming the rape victims because of the rape victims is was being happened. Second is the administration of the justice. When a criminal justice use this kind of the defense as a, in the any use as a defense in the criminal justice system, the criminal justice system of the country which may not a fair enough. Is not can give a fair justice to the victims from the criminals case, from the criminal charges or any other civil or any other sentences. And in not only in the criminal cases, it can be use any defense in any other source. It can be it's not give any fair enough of justice for the victims. Next is the problem statement. Based on my research was conducting, the my research was conducting because of this problem statement. Because in our country recently, the number of the rape cases was increasing when we compare with the last years, and also the positive urine of the drug also increasing 30.6% when we compare the last year to 2021. The statements was being given by the DOSHMS, which is the Department of the Strategies of Malaysia, based on the PDRM's reports and also ADK reports as well. Based on this statement, based on this report that launches by Russians of Russian's department, we can clearly identify that in Malaysia currently, our in Malaysia's currently rape cases are rapidly increasing by increasing in overall of our country. It doesn't matter in which state was increasing. In Malaysia's overall the cases was so increasing, and also the number of the positive urines of alcohol and also drug also was increasing 30.6% when we compare with last year's. This is because happen because of the lack of the clarity and the current legal framework on the rape cases. When the rape cases, the punishments of the rape cases or the judgments that given in the rape cases was have a clear and strengthening the punishments of the rape cases, the accused actually feel afraid to commit in these crimes. But because of the some cases and the lack of the clarity, the current of the legal framework, this will be happens repeatedly in our country. And second is the positive of the urines of the drug. It is because of in today's society, in today's modern era, most of the alcohol and also drugs are available easily in surrounding of the peoples. It's really easy to them to have it in easy way. It let's say in for we talking about the alcohol. When we talking about alcohol is available in our store, in our pasaraya store as well. Like it's a Speedmart or any 7-Elevens. It's easy to them to grab it in any time when they want to have it. So this kind of the availability is viable in our in country is one of the reasons why the cases of intoxicated by the persons was increasing. It's not only they are committed in the criminal cases, some of them people also are having more alcohol. It can be intoxicated, then it's not aware what the act they do that was admitted. That is the that is the starter thing that we to a person is consuming alcohol or drug also. For the drug in current scenario of our country, drug cases also increasing rapidly. The drug is also viable in anywhere when the peoples want to have it. When they want, they can be contact any drugs dealers. It's easily to them to contact the dealers by their friends, by the persons who's drug addicted as well. They can be be contact them to get the drug to have it. So this is the kind of the things. This is the kind of the problems that can be increasing this kind of the criminal cases in our Malaysians. Second is the objective and research methodology of my legal research. The main objective of my legal research to examine the prevalence, the legal acceptance of institutions as a defense in the rape cases, and also to analyze the effectiveness of assessing legal implications use of institutions as a defense in the rape cases with the legal system. My research methodology I'm used to explore this research paper. I aim to I aim to conduct this research in the way of the qualitative research methodology. Qualitative research methodology I'm refer to informants who's a to informants or professional informants who's expertise in the criminals cases, which is the lawyers. This is the research methodology. This is the informations of the research methodology that I have conducting. The professional interview with the two professional lawyers who are expertise in the criminal law. My first informant is lawyer Arvind Raj. The age of the his age is 32 years old, and the positions of the lawyer is expertise in the criminal field, criminal lawyer, and he have experience in 7 years. Based on during my during my interview sessions, he also explained to me on the experience in the rape cases as well. My second informant is Puan Shifa bin Hassan. She was 36 years old, and is also she also he's also criminal lawyer, and his experience in 9 years as a criminal lawyer in the experience in 9 years in the as a criminal lawyer. Next is the literature review. Literature review, I have covered 50 articles, but here I am putting 10 article to which is discussed about my topic. The first literature reviews that I'm refer the article is why the extreme integrations defense is dangerous for the human. In this article, they are explain the impact of extreme institutions defense in the criminal justice system, particularly in the case of sexual violence against the human. When the person, when the accused must be extreme in situations, it can be cause or danger for the humans. Not only it can be hurt, it can be cause anything like it can be cause death for the humans also, because the accused was not aware what they are with the act of he admitted actually, because extreme institutions defense will be identified based on the percentage of the investigations of the of instant how much the percentage of the persons was intoxicated. Explain like we consume one can of the alcohol, it's let's say that is not can be considered it can be can it's not can be give can be cause extreme intoxications. It may be feel like we not be we not be like not intoxicated because it's just one of the one can of the alcohol only. So based on that, it can be identified whether the accused was be extreme intoxications or not. Second is tracing the bias and voluntary intoxications sexual assault in case. This article was be explained the impact of the voluntary intoxications. Is voluntary intoxication, as we know, the accused must be voluntary to be intoxicated. It's not anyone is put any drugs in in their in the drinks that the accused was consumed. In this case, the accused must be voluntary to having to intoxicated, and because of it was intoxicated, the act was made admitted because the crime was made admitted because he know when he intoxicated, it can be cause a negative impact. Like in let's say one of the scenario that can be given during a pub a night when the accused was we went to the pub and also drink extremely voluntary is drink extremely in the purpose of he want to fight with the girlfriend, or you want to fight with your friends. Because of that, they want to extremely instigated to conducting that kind of the to creating that kind of the scenarios in these circumstances. Second is a justice for the rape with rape complaints, limitations, and possibility. In this article, the author was explain the possibility of the justice that we can be get by the victims, how the legal system can be give the fair justice for the rape victims. Second is the Canada top court says voluntary extreme interventions as a defense in a violent. Yes, when I'm connecting with these reaches, I'm also refer more of most of the article of the other country criminal justice system. Some of the country was accepted institutions as the defense in the criminal cases. When we compare with that is the main loopholes that can be identified. What the kind of the impact can be considered when the criminal justice system was accepted is such as defense when a criminal justice another country of criminal justice is not accepted in such as defense in the criminal cases. So in this article is one of the best article that I've refer for my research that there is not that have many loopholes I can be found because in this case the country was accepted insurgents as a defense. When we compare with in our Malaysia's criminal justice system, in Malaysia, insurgents as a defense is not considered as a fairly defense in any criminal charges. It's not only rapes in other criminal charges also. Next is instated but is not incapacitated as the effective method to arise the jury's interpreting evidence of voluntary complaint. Okay, this article is was being explained that how the instigated can be a method used a method to be a defense in the any criminal charges. To use that is the evidence to interpreting the judgments of the court. Maybe the accused can be used this defense to interpreting that they can be say I'm not aware to admit the act that was admitted during that time because I am intoxicated, but in later cases based on I'm conducting the qualitative methodology that they do it two lawyers, they also explain that during when a person state that I'm intoxicated, I'm not aware that the act that was admitted during the circumstances. Then how they can be insert the man genitalia to into the woman vagina? That is the thing. When a person is intoxicated, he is not able to do that. So that is the loopholes when it's usually the lawyers and public prosecutors that are found in the rape cases when they use insurgents as a defense. Second is the victim rights, or from restorative perspective, the article explores the significance of victim rights in the context of restorative justice. The restorative justice focus on the healing, rebuilding the relationship between offenders, victim, and the communities. Okay, this article is basically explain about the rights of the victims, based on how the victims can be get the rights and what is the kind of the rights the victims as have to fight against the case against the accused during the because of the rape, because of the sexual assault as well. Next is a time of the for a rethink victims and restorative justice. This paper is proposing a new perspective of subject for restorative justice, particularly considering its impact on the victim. The base time of rethink indicate there might have been a previous approach on openness in the matter that we revoked an opinion. This article is explained about the victims to rethink how the justice rethink about the criminal justice systems to get the fair enough justice to the victims because of the rape cases. Second is the Supreme of Canada rules extreme sensitive available for violent crime or exercise. The Supreme Court of the Canada has ruled that extreme insertion consider different or violent crimes, including the potential future cases of actions. This is one of the example is one of the example article that we compare with our Malaysia criminal system with the other country criminal system as we explain another as explained previously. This is one of the another article that I mentions that the Supreme Court of the Canada rules extreme insurrection as a defense is a viable any violent crimes is include the sexual assault cases. Next is institutions do the drugs as a defense by Ramalingam is that this case article was brought to by the public prosecutors of Malaysia, which is Ramalingam. This article was explained about the drug indications as a legal defense in situations where the individual commits a crime wrongful under the influence of the drugs. Maybe in these cases they were in this article they was explained the cases there the accused was used in the citizens defense in the criminal cases because they are consuming the extreme intoxicating drugs. Next is the insulting but is not incapacitive. This is one of the related article to the previous article. In this article, there was explained the effective method that the jurist was using to prove the voluntary evidence of the investigations of the rape. And these cases were in this article was explained about the jury's instructions towards the investigations defense in the rape cases. Next is my findings and analysis. Based on my finding analysis to conducting this kind of this research based on my topic, the effectiveness of investigations as a defense in the rape cases and an exploration justice for the victims. Based on my findings analysis to conducting this research, I have found that insubstitution is not a valid defense under the Malaysian's law. Malaysian's criminal justice system is not be considered a valid defense in any criminal charges unless it's maybe falling under sections 85 of clause 2 when the persons were intoxicated but innocent to act there what was admitted in like hurt someone push someone is it's extreme intoxication but you push someone because of the act they are caused some injury. In these cases it can be used in cases as a defense but is not applicable for the violence crimes. Second is the institution defense cannot be used or manipulate the legal system undermine the credibility of the so because of the institution defense to use any country of the criminal justice system is cannot be manipulated the legal system to undermine the credibility of the rape victim because they when the accused also was intoxicated they also cannot be able to give in the true statement to the police officers to the lawyers as well when they do not able to give the true statement of what is actually was happened then how they can be say that because of the victims what this was what happened the he also is not given the true statement to the police because he also don't know what actually was happened because he was intoxicated during that time but then how they can may undermine the credibility of the rape victims they you may say because of let's say when committed in rape when the case was committed in rape it was instigated extreme instigated and during the statement he giving that because of the trust of the rape and the victims is make me to is make me to committed in rape is it is it's not a valid statements or it's not it's not a very statement that we can be considered that is the reason to the accused was committed in rape. Second is the legal framework regarding institutions of defense because it's clear and consistent. In Malaysia, the legal framework regarding institutions as a defense institutions as a defense in a violent in a criminal justice was clear and consistent. Is because of say they already was stated that in our penal code institution as a defense is not considered a valid defense to a violence crime unless it can be established institution as a defense in the certain circumstances like I explained previously because it was institution it put someone and it caused injury so that in this case, it can be established intention as a defense, but it not can be considered. It not it's not able. It's not considered to establish. It's not considered a valid defense in the violence crime to establish as a intention as a defense, and moreover, in based on my finding and results when I'm conducting research based I refer the case laws and also I'm conducting qualitative research methodology and I have interviewed two professional lawyers based on their opinions based on their experience also they based on the experience I'm summarizing that finding based on the based on my research methodology what I'm get is um insubstitutions is not a valid defense in the rape case. It cannot be cannot consider a valid defense in our country, and also it can is when they are when there are when in the legal frameworks have the clear and consistent about the legal framework regarding the insult questions, it can be bring a fair justice for the rape victims. Usually in our Malaysia, in Malaysia for the rape cases when they are used insult defense, the code is not considered is a valid defense for the accused from the acquitted from the charge. They during the sentences they will the cases was be favored to the rape victims to get a fair justice for the rape victims. My recommendations towards of my research is first is conducting a comprehensive review of the legal framework surrounding rape cases in Malaysia. In Malaysia, the criminal justice system should be conduct a comprehensive review to reducing the increasing of the rape cases in Malaysia. They should be review the judgments of the previous cases. Why when the punishment is also strengthening, why the cases was repeatedly happens in our Malaysia. Second is revise the legal framework to explicitly the intention cases now really depends as the big cases. For the uh, for the uh, for the use of the insult cases as a defense in the rape cases, the legal framework should be revised to me revise the legal framework to establish the to mention the clear to mention clearly that insult is not a valid defense in the rape cases. Second is to revise the legal framework as uh, separate to valid difference. It's the same point actually. So next, moving to the next point, which is establish a comprehensive support against the victims of sexual violence. Okay, for the rape victims in our country, our governments or our NGOs, they should be give a supporting system for the victims from the victims of the sexual violence because not only it's not only enough that can for the victims to get a fair justice. It might be might be need some supporting system to uh, to giving the treatment, to giving something to care for them to recover from the incident because for the to begin the victims of the remedy it's not easy to recover from the trauma. It's a long term trauma for them. Second, next is strengthen punishments for the rape cases to reform the laws to the increase the punishment for the perpetrators. The criminal justice should be uh, should should be strengthening the punishments of the rape to reform the laws to increase the punishment in this kind of the cases. They must be give the hardest punishment from the accused when they committed in the rape. That is the kind of one of the way to give enough justice for the victims as well, and is the way to overcome the other community to committed this kind of the to committed in this kind of the crime because they can be away because to refer the previous judgment or if we are committed in this crime we can be get this punishment. Let's say for not only enough to have the imprisonment but or wiping, it can be if the persons was be caused a rape for the humans which can be cause a death or it can be which the, because of the committed rape in the humans must get the pregnancy. In this kind of the situation sentences, it can criminal justice can be give the hardest punishment like a lifetime imprisonment because the homo cannot be accepted the sentences because of the rape he get a pregnancy is having a baby having a child, but in reality the woman is do not know who's the man. So that is kind of the really is a painful situation for the humans to overcome to accept the circumstances in their life. Second is to implement the victim-centered justice initiative provide a trauma-informed supportive service. This is one of the best way to give to provide the victims to initiative provide initiative service like to rehabilitations to provide the medical care for them or supporting care. Some of the humans are maybe they do not have any closest or family members or family's parents on this kind of the situation. The NGOs or the criminal justice can be create a one center for the victims to recover themselves from the from incidents as well. Next is the conclusions. In order to effectively address these issues in situations as a defendant in their cases, it is actually a critical implement and comprehensive and multi-factor approach that include the legal reform, education's awareness campaign, support and services for the victims. By revising the legal framework to explicitly the state that instruction is not a valid defense in the rape cases, it can be promoting cultures of concern and respect through the education awareness campaigns. In providing a true informed support for the victims, we can create a more just, equitable criminal justice system that prioritizes the needs and well-being of the survivors of the rape and sexual abuse. To 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 sum up everything, to refer the recommendations and also to refer the legal farmers of our mentions criminal justice, we can be a created a fair criminal justice system that can be prioritize the needs of the well-being of the survivors of the rape victims in the sexual violence cases. That is my conclusions. That's only for me today. That is, thank you so much for watching my presentation video. Thank you.